Welcome, everyone, to the City Bar Association debate on the ethical standards for United States Supreme Court justices. Before we begin, just a few introductory remarks. We have set aside time at the end of the program for questions from the audience. And the panel certainly encourages all questions that you may want to ask. Whenever you think of a question, if you could just hit the bottom of the screen, the Q&A question, and just ask the question, and you can include your name or not include your name. And then at the end of the program, we're saving 15 minutes for questions, and we'll remind everyone again to submit the questions. I think we should start by introducing our panelists. Alicia Bannon is the director of the Judiciary program at the Brennan Center for Justice, and she manages the Brennan Center's projects on fair courts and redistricting. In her earlier life, she clerked for Justice Sonia Sotomayor when Justice Sotomayor was on the Second Circuit. Judge Nancy Gertner is a senior lecturer at Harvard Law School. She previously was a federal district judge in Massachusetts, and more recently has served as a member of President Biden's Presidential Commission on the Supreme Court. Steve Gillers is the Elihu Root Professor of Law at NYU and has written widely on legal and judicial ethics. He was a member of the ABA Commission on Ethics 2020 and is the author of the law school casebook, Regulation of Lawyers, Problem of Lawyers and Ethics. Tom Morgan is a professor emeritus at George Washington School of Law. He's an expert in professional responsibility. He was selected by the ALI as one of 3 professors to prepare its new restatement of law governing lawyers, and by the ABA as one of 3 professors to draft provisions to the Code of Model Rules of Professional Conduct. And finally, last but not least, other than in the alphabetical order, is Russ Wheeler, is a non-resident senior fellow at the Brookings Institution's Governance Studies Program, and a former deputy director at the Federal Judicial Center, the Federal Courts Research and Education Agency. He has written extensively on judicial independence and accountability and judicial governance. So welcome to our panelists. So let me start. To summarize as I see the issue boiled down to one sentence. Today, the 9 justices of the United States Supreme Court are the only U.S. judges, state or federal, not governed by a code of ethical conduct. Tonight, the panel members will debate whether there is in fact an ethics problem on the Supreme Court today, and if so, what, in the views of each of the panelists, should the ethical rules governing Supreme Court judges be, and how shall those rules be enforced? And given the political divisions that exist in this country today, time permitting, panel members may also discuss how to persuade the court or Congress to adopt ethical rules. Before we begin the discussion, we would like to briefly poll the audience with 2 questions. We'll ask a final question at the end. But I'm now going to ask the Bar Association technical person to put up the first question that we would like everyone to view, and then you enter your answers in the Q&A tab below. So, Bar Association, there we go. Just check your box and click, and then you're done. Okay. All right, you can, and I think we can now put up the answers that as soon as you're ready, Jonathan.
Wow.
Okay. Very good. Well, thank you all for your participation in the poll. And everyone, I assume, has now seen the results. Okay. So now let's get to the program started. I assume that most of our audience is familiar with the present issues involving ethical actions by members of the Supreme Court. And I think the summary of what's happened in the last 50 years on ethics was aptly summarized by Mr. Wheeler, one of our panelists, who wrote, "The regulation of federal judges' ethics, including Supreme Court justices, has been a recurrent topic throughout American history. In just the last half century, aberrant federal judicial behavior, including the Justice Fortas controversy, prompted the Judicial Conference to adopt its Code of Conduct for the United States Judges in 1973, and Congress to enact the 1980 Judicial Conduct and Disability Act. And as we all know, recently, there's obviously been a great deal of publicity about ethical issues involving Justice Thomas, as well as questions of recusal by some judges and some public comments that people question whether the Supreme Court judges should be uttering. So I thought it would be helpful before we get into the actual debate to gain a bit of a background on how to try to solve these problems. And I want to ask Professor Gillers to explain the ethical rules that today govern the Supreme Court and other federal judges. Professor Gillers.
Thank you, Michael. There are 5 sources that anyone studying this material would have to look at. One is the Code of Conduct, the United States Judges, which is generated by the Judicial Conference of the United States. It's a statutory body composed of district and circuit judges and headed by the Chief Justice. The Code of Conduct for U.S. judges by its terms only applies to federal judges below the Supreme Court. It seems that the conference does not believe it has the authority to write ethics rules for the court. Some people take issue with that. They think it does. Then there is a statute, 28 U.S.C. 351, which governs complaints about the behavior of federal judges below the Supreme Court, not the justices. A disciplinary proceeding against a federal judge under this statute requires proof that the judge engaged in conduct prejudicial to the effective and expeditious administration of the business of the courts. In other words, a federal judge cannot be disciplined for violating the Code of Conduct for U.S. judges. That the code may bear some relevance to whether or not Section 351 standard has or has not been violated, but discipline can only occur under Section 351. Then there is the Ethics in Government Act. The Ethics in Government Act is a statute. It applies to all federal judicial officers, including the justices. So if we're thinking about congressional power to make rules for the justices, this statute makes rules for the justices. Together with another statute, the Federal Gift Statute, the two of them require, among other things, all federal judicial officers to disclose a host of financial information, but also gifts and personal hospitality, a phrase that may be discussed here tonight. Annually, federal judges, including the justices, have to file long forms detailing answers to all the questions asked by the Ethics in Government Act. In March, the Judicial Conference amended the disclosure rules to ensure that personal gifts that do not have to be disclosed are really personal, that they're not through an entity or an organization, but they come from the donor's personal assets. So that's the Ethics in Government Act and the Federal Gift Statute. Now, both of those together don't deal with the work of the court, and that's important when we come to the next and final item. Both of them deal with disclosure of information about the judge or justice, not deciding cases. The final item is the recusal statute. There are really two. One gets no or very little attention. The one that gets all the attention is 28 U.S.C. 455, and it gets the most attention because it has the most, the provision with the least clarity of all the provisions we're talking about. It says that a judge or justice's recusal is required if his or her impartiality, quote, might reasonably be questioned. The recusal statute is enforced by self-policing. That is, there's no other body to which you can appeal if a judge or justice declines to recuse. Although if a judge declines to recuse, you may have an appeal to a higher court, if and when you can get to that higher court. The other statute dealing with recusal is section 144. It does allow a litigant, a party, to allege with detail a claim that a judge is personally biased. We're not talking about appearances. We're talking about personal bias toward that litigant or in favor of the adversary of that litigant. And if a litigant can satisfy the procedural requirements for section 144, then another judge, not the subject judge, will decide the case. 144 is often cited, but all of the action is occurring around section 455. And that's the source material, Michael.
Thank you very much. Does we don't want to get in the debate yet, but do any of you want to, any of the panelists want to add to that fulsome presentation? I would just observe that, of course, both the Senate and the House have their own ethics rules as well. I assume that the members of the Senate and House have to comply with. So I think that gives us a background. And now the question before us is, what should we do? And what should the rules be? And how do they get enforced? Who wants to start giving his or her view before I? Okay. Judge, we only have one person I have told that should guest is the judge on the panel. So Judge Gertner, what do you think?
Where do I begin is the answer. It seems to me that there are two levels here. One is a judicial code of conduct for the Supreme Court. And I find it mystifying that the court has not expressly adopted one for itself, the Supreme Court, as every corporation has, as entities across the country have done. Let me just say a sort of a moment of humor. I took Justice Roberts's letter to the to Senator Durbin about why he didn't appear before the Senate committee as the functional equivalent of a 4-year-old saying, I'm not going to do it. You can't make me. You're not the boss of me. Right? We're not going to do it. Let's start with that. There really is no excuse for the court not adopting its own code of conduct. Particularly given the dislocations and the accusations of the past couple of years, there's really no excuse for them to say, we understand there is a problem and therefore we would do it. Originally, I was skeptical of the judicial conference adopting a code of conduct for the Supreme Court, just because of the deference to which the judges are shown. But I now think that that would not be a bad idea to have the judicial conference adopt a code of conduct, mainly because from a unscientific review of the judges across the country, there are not many people I have talked to who are not angry at the disclosure issues with respect to Justice Thomas in particular. Those of us who have labored over these disclosure forms. The broader question about, and the Supreme Court is clearly bound by the Disclosure Act, which they expressly are part of, which means that Justice Thomas's failure to record the incredible generosity he's gotten from Harlan Crow, from with respect to his travel, with respect to his mother's house, with respect to travel to New Haven, which doesn't look like personal hospitality. To me, all of these kinds of issues, it seems to me, are a blatant violation of the disclosure rules. So and that is a statute, Professor Gillis, correct me if I'm wrong, that has civil penalties and for willful violations, even a criminal referral. So the area that has been the subject of so much discussion over the past couple of months is in fact an area that is regulated. Not as well as it might be, but it is in fact an area that is regulated. And finally, with respect to recusal, the standard argument about how the Supreme Court can't have an enforceable recusal system, putting aside how to enforce any of this, the answer would be that there are only 9 of them, and that therefore it could affect the outcome of a case. This is true. I'm part of the group on the White House Commission who believe that the Supreme Court should be expanded. And perhaps this is now a new rationale for expansion, is that having a larger court would enable recusals when they are appropriate. The other issue with respect to recusal is the Supreme Court already takes fewer and fewer cases over the years. And so if there is a recusal issue, they don't take the case. The notion that I think in general, my general perspective on this is the notion that these issues are intractable is false. The question is only what we're going to do, not whether we do anything. And I think the time for a hands-off approach is over. Other than that, I have no opinions, Michael.
Okay, I have a feeling from facial expressions, some of your colleagues have some further thoughts. Tom Morgan? You're muted. You're muted, Tom. Okay.
I think it is helpful to have the provocative remarks of Judge Gertner to start us off. But I also think it's helpful to get some perspective on what does govern the Supreme Court, what they consider governs them. Just a little over 50 years ago, as Steve Gillers reminded us, almost no judges in this country were governed by a code of ethics. That doesn't mean that they were not subject to ethical standards, that they were not required to recuse themselves in appropriate cases, and the like. The law relating to ethics for both lawyers and judges was developed over many years in courts of law and equity and used to regulate the conduct of both lawyers and judges. It was the period around Watergate and around other discouraging instances of behavior by judges that led to the effort to codify both the state court judges, and that was done by the American Bar Association and later adopted by state legislatures and courts, and by the federal judicial system acting through the judicial conference that was created about the same time. There was earlier debate about generating ethical codes, but this is really a relatively recent phenomenon. I join those who say that the Supreme Court is having a terrible struggle, apparently, to join the trend that has been adopted in the states and in the rest of the federal judiciary. I don't understand why they are unwilling to adopt in code form what they have acknowledged in the statements by Chief Justice Rehnquist in 1991 and by Chief Justice Roberts in the letter that Judge Gertner was bothered by. They understand that they are subject to important ethical standards. And I'm going to be suggesting tonight that the evidence I've seen indicates that even Justice Thomas, who's gotten all the grief lately, appears to me to have been trying to comply with his disclosure obligations. We can discuss that, we can debate that, disagree about it. But the point is, we're not dealing here with a question of 9 people who somehow just don't get it and don't see themselves as subject to ethical requirements. They do see that. And I think they ought to codify it just to get the issue off the table and not have themselves appear to be indifferent. But I don't agree that we have a serious problem in this area.
Mr. Wheeler.
Well, I agree with both Judge Gertner and Professor Morgan that the court it's a self-inflicted wound now. And why it doesn't adopt a code of conduct, it just escapes me. All I can attribute it to, I don't know, is just a little bit of obstinance that maybe some of the justices don't want to look like they're being forced into doing something. But it would certainly make some of its problems go away. But that doesn't really deal with the basic problem. That is, how does one enforce a code of conduct? The code of conduct for district judges is, as Professor Giller said, is a source of guidance, and a lot of it is in very general terms. In fact, it says that judges may disagree about some of the provisions in the code, which is hardly typical of a civil or criminal statute. But we get to the question of enforcement, and there have been a variety of notions put forward. I think none of them are likely of enactment in this political environment, although I see no reason why they can't be discussed. Some of the legislation in Congress would create an ethics officer within the Supreme Court who would, I guess, admonish the justices when they seem to be violating the code. I am not persuaded that an enforcement mechanism similar to Chapter 16, Section 351, to which Professor Giller's referred, would be the end of the world. And having judges, not simply Supreme Court justices, resolve the relatively few judicial conduct complaints that might be filed. I would note that in the states, every judicial discipline mechanism reaches conduct by the justices of the state Supreme Court. Justice Kennedy has said there'll be a dissonance problem. And Justice Alito said we'd find it unhelpful to have lower court judges passing on the behavior of Supreme Court justices. But I don't think that is by itself a reason enough to rule out its adoption. I'm not necessarily advocating it, but I think we have to think fairly broadly. So too about recusal. Texas Supreme Court has a recusal provision that judges either grant a recusal motion or they refer it to the whole court for a decision. I would like to see some investigation of how that works rather than assume, as some do, that it would create a tactical nightmare of parties trying to get judges recused in order to build their alliance on the court. So I think we have to talk more about enforcement, even though I don't think enforcement mechanisms are on the horizon.
Thank you. Alicia, what do you think?
Thank you, and thanks for the opportunity to participate today. I'll start by just saying something that should, I hope go without saying, which is that the Supreme Court should be held to the highest standard. I think sometimes we lose sight of that. They're the most powerful court in the nation. They're the highest profile. Their decisions are largely unreviewable. They have nearly total control over their dockets. And they're also public servants, which I think altogether suggests that there should be very strong ethical precepts binding them. And I too have been mystified by the court's continued unwillingness to adopt voluntarily a code of conduct, and think it is within Congress's power to require one if, in the event that the court continues to refuse to adopt one on its own. A few other points I just wanted to raise. There's a vast psychology literature about how people are incredibly bad judges of their own biases. And I think that's another just important thing to be thinking about, particularly as we're speaking around both the importance of a code of conduct, which can, serve a prophylactic effect, sort of avoid putting yourself in a bad, potentially bias creating situation in the first place, as well as setting clear standards upfront transparently that can be debated and then you can be held accountable to. And then also around the importance of having transparency with respect to recusal and, and having some process for, independent review of recusal. I was just looking, at some of the literature before this panel, and I'd just like to highlight a few points that just really jumped out at me. There's a whole host of studies suggesting, for example, individuals, not only judges, but judges are people too, that people believe that their judgments are less susceptible to bias than the judgments of others. Individuals will often ignore or rationalize facts or ideas that threaten to undermine their pre-existing self-images. There's a whole literature of what's called egocentric bias, that we construe information so as to protect or enhance our own self-images or our own self-esteem. And these are all dynamics that, are part of human psychology. And I think if you, sort of looking at the lens of some of the recent controversies around the Supreme Court, like I'm seeing some egocentric bias at play. And so I think it's important as we're sort of thinking about these to just kind of come back to some basics about why these are so important in the first place. And the fact that I think the court has really had blinders about, its own ability to self-police. I think Russell and others have highlighted the challenges around enforceability, and I think that is a huge issue. I do think there are some interesting proposals out there. So for example, I've thought it was, I saw, so Senator Warren recently released a bill that, for example, had the Judicial Conference authorized to issue advisory opinions with respect to recusal. So not binding the justices to abide by that, but kind of putting something out there that then the justices would need to respond to, and also requiring reason giving with respect to recusal decisions. There's also various proposals. I know you mentioned some around different ways you could have review committees. I think it's interesting, and there's pros and cons here with all of these, but Congress, because they do have impeachment power, I think there are ways that you could create systems to sort of further investigate allegations of misconduct within the judiciary, kind of rooted in Congress's impeachment authority, that are worth investigating and thinking about as well.
Can I just add something, Michael?
Yeah.
This is something that Russ Reeler's comments made me think of. The Supreme Court is essentially saying, you don't need to impose a code on us. We are norm followers. We know what the rules are, and we will follow them, rest assured. And then we talk about enforcement, which is usually sort of punitive, bringing down the hammer. But there's an intermediate position, which Alicia was talking about, which is very interesting. If there were a mechanism to do an investigation and make a report, the notion would be that maybe this Supreme Court, which are the rule followers and saying, we don't, we're going to follow the norms without any kind of punitive measures at the end of the stick, but would a report, an internal investigation and a report by the judicial conference, by some kind of subcommittee of the court, by a subcommittee of chief justices, judges across the country, doesn't that even add to the structure of enforcement that the Supreme Court is saying? We're norm followers. Well, here, if somebody has pointed out that you've done something wrong, surely that should, whether or not there's any enforcement attached to it, surely that should make a difference. Otherwise, we're in a situation that there is either impeachment, the court saying, hey, we are norm followers, or the press. And I, for one, would rather see an investigative mechanism that isn't, only political. And whether that would make a difference, just to encourage the justices to change.
Well, Professor Gillis, you've been quiet for a couple of minutes. What do you think?
Well, I'm in the uncommon position for me in being in the go slow camp for these reasons. First, the first 200 years of the court, we didn't have the problem we have now until the early 90s, the mid 90s. Second, we have the problem we have now because of the Thomases, it must be said. Before they arrived in Washington, it was a reliance on norms and respect for the institution and self-restraint that kept us from being in this dilemma. And someday they will leave Washington, and hopefully we will be able to revive the earlier time. Second or third, I fear the unintended consequences of any more dramatic change than having the court itself adopt a code, if it only will. I don't know where it will lead. For one thing, at least through half my life, I've trusted the court, any one court in any one year, more than I've trusted Congress. So if I had to be governed by the Supreme Court or by Congress, if I had to rely on the good faith and acuity of the rulemaker, I'd rather it be the justices than the Congress. There are times that has not been so, but at least half the time it has been so. And I fear adoption of a rule that will strengthen Congress's power over the court at a time when it is not so. I think that the Congress adopting a statute or a sense of Congress with rules for the Supreme Court, if all else fails, I can go there. I'm hoping all else does not fail. But I also recognize that if Congress does that, then what? The court ignores it. And then what? What are you going to do? It has symbolic value. And if the court ignores it, we might be in a worse position than we're in now. So for all these reasons, I think if we could only get the court to adopt its own code, we solve a lot of problems, including the public's perception of the court. Just saying, this is our code. we are duty bound to honor it. We accept this as we accept the Ethics in Government Act and we accept the recusal statute. We pledge that. It may not be enforceable, but taking an oath, which this is in effect, can accomplish a whole lot in the minds of the viewer. And that's what I favor. Why Roberts does not do this? It's so easy. He could write the code. You could take the code of conduct for US judges and revise it to address the particular situation of the Supreme Court. And that would be it. You can do that in less than a day. We can get through this next week if we had cooperation in the court.
And what is the relevance, if I can just interject here, what is the relevance of the political, the Democrats versus Republicans on this? Is that an issue in this at all? Any, Tom?
Michael, I would just read very briefly a statement. An independent judiciary is one of this nation's outstanding characteristics. Once a federal judge is confirmed by the Senate and takes his oath, he is independent of every other judge. He commonly works with other federal judges who are likewise sovereign, but neither one alone nor any number banded together can act as censor and place sanctions on him. Under the Constitution, the only leverage that can be asserted against him is impeachment. That sounds like it might have been written yesterday, but it was written in 1970 by Justices Black and Douglas. And you may remember Justice Douglas was under vigorous assault during a significant portion of his service by the Republicans. I think there's no question that a lot of the divide in this country today is getting manifested as an attack on the court and as an attack on a perceived imbalance on the court. But those will come and go. The question is how we deal with the preservation and the strengthening of one of the three branches of government, one that I think everybody on this panel views probably as definitely worth preserving. And it is that concern, the fact that what's done today can come back to hurt people for generations in the future is what makes this topic so interesting. And I agree with Stephen Giller's analysis of the need to deal carefully, but to encourage the court to seize the opportunity to take the knife out of what Russell Wheeler called the self-inflicted wound.
What is there any influence in the fact that the courts does seem to have less support from the general public? It used to be that the general public, when polled, would say, the percentages were astronomical. And I think Judge Gertner has indicated some polls that the support for the court is plummeting. Is that of any relevance to what should be done or what will be done?
I'd like to.
I'm sorry.
Go ahead. Go ahead, Alicia.
Well, I'll just say briefly, I certainly think that is both reflective of, the series of ethics breaches, as well as other, radical and norm-breaking behavior that we have seen from the court in recent years. And I think feeds into the urgency of reform, or the need for reform. At a basic level, I would say legitimacy needs to be earned. And in a lot of basic ways, including the continued refusal to adopt a code of conduct, which, is frankly the bare minimum of what one might ask of the court is I think deeply troubling from that perspective. One other point I just wanted to make with respect to that, I do a lot of work on judicial independence issues in the states. And so I have definitely seen, where in a lot of states, those norms are very weak. And we see a lot of really troubling assaults on judicial independence, frivolous efforts to impeach judges simply for unpopular rulings, politicizing judicial selection, stripping jurisdiction, you name it. All things that would be, very much out of norms in the federal context, but very much the reality in the states. And so I both really understand, and I think the value of judicial independence, and particularly the institutional independence of the judicial branch, is a very important value. I worry, though, that on the federal side, the states have gone too much in one direction. I fear that we've sort of overlearned that lesson in the federal context, such that Congress has kind of abdicated any role whatsoever. And, we talk about separation of powers, but the other side of separation of powers is checks and balances. And I do think that we have seen now a norm of simply, Congress being afraid to sort of touch the Supreme Court at all, even in ways that I would say are still very consistent with values of judicial independence properly understood.
Very good. Maybe we should ask, assuming we had rules, what should they cover? For example, do they cover actions by the spouse, which has been raised, or contributions by the spouse? Do they include speaking out on public issues that Ruth Ginsburg, I think, have been accused of going too far in that connection? So just to change the topic a little bit, if you were writing the rules, what kinds of subjects do they cover? You can't accept gifts, or you can accept gifts, etc. Any of you have any thoughts on that?
We're waiting for Russell.
Go ahead.
No, you go ahead.
Generally, codes of conduct are fairly, they don't have to be, they vary, but they're generally fairly general, and they have a lot of well-taken generalities. How specific they ought to get, though, I think is a different question. For example, I've heard a lot of people say, if there were a Supreme Court code of conduct, Justice Thomas would have had more restrictions on his reporting requirements, which really confuses a code of conduct which admonishes judges to do things, and the specific regulations that the Judicial Conference has adopted and that the Supreme Court has agreed to abide by. All the code of conduct says, for example, about gifts and reporting is judges ought to obey the gift and reporting requirements that are on the books. And I think that's what a code of conduct would do. So, I mean, I really think the code of conduct for United States judges, with a few tweaks, could apply to the Supreme Court very well. The Project on Government Oversight produced in March a code of conduct for the Supreme Court, and it doesn't stray very much from the current code of conduct. It does say a few things, admonishes, basically, I think, admonishes judges to be a little more concerned about what some of their spouses are doing, an extension of this notion that judges ought to accept some burdens on their, some restrictions on their behavior that ordinary citizens would find burdensome. I think that could in a code could be expended to an admonition to judges and their families, but I don't think it can go much beyond that in specifics.
With respect to families.
Yeah.
I agree with that. I think I appreciate Professor Giller's concern about going slow, but I think this is a sui generis moment. And I think it's a sui generis moment, not just because of Justice Thomas and the Justice Thomas's disclosure issues, but also Justice Thomas's recusal issues and the extraordinary lack of reaction from the court. So I think it's a really sui generis moment. We don't need any more regulations with respect to disclosure, except I think Professor Giller's, you on other calls have suggested that we might want to expand disclosure to include hospitality above a certain amount of money. But the Thomas issue is a blatant failure to disclose material information which he was supposed to have disclosed. There was an arguable interpretation But if you care about the rules and the purposes behind the rules, you would have erred on the side of disclosure. And so I think we have an enforcement mechanism for that. Code of conduct issue is different, and I agree with Russell that the code of conduct of the federal courts can be, adopted. But it really is a sui generis moment in the sense that the accusations against Justice Thomas and an extraordinarily divisive Supreme Court. So I think there has to be a response. And let me just say one final point. The notion that having to only be paid, what was it, $25,000 for my teaching at Yale and not a penny more, or having to disclose every time our mutual funds changed hands, didn't affect my independence, didn't affect judicial independence at all. And the disclosure issues, it seems to me, do not affect judicial independence. They affect judicial transparency, and we all should be concerned about that.
What about the enforcement mechanism? I think all of you seem to be saying, let's have a code and disclosures, and that's to be it. Who's going to enforce this and how?
I'd like to say one thing. I did not mean to suggest earlier that I was in favor of, I think what you referred to as, Judge Gertner referred to as bring down the hammer. I think the recommendation you had about an unbiased third-party investigation of serious allegations of misconduct would serve the enforcement mechanism. It would do two things. It would make justices a little less reluctant to do stuff if they were afraid it would be investigated seriously. And it would have the effect of just putting on the public record a conclusion that the justice had taken some actions which that justice probably shouldn't have taken. But I do think we don't want to deceive people into thinking that once a code is adopted, we just go like this and say, okay, that's the end of it. Some mechanism doesn't have to be a lock them up kind of a mechanism, ought to be there to deal not with every case, but deal with a few cases in which there really is something more than just a momentary infraction.
I think Russell makes a really important point. I think ultimately we need to sort of change some norms on the court. And one way of doing that is by shifting incentives, creating transparency, requiring reason giving, all things that I think can encourage behavioral shifts. Because it allows for more kind of public scrutiny, and as I forget who said it, somebody talked about ultimately hopefully the justices will be norm following if it is put in those terms toward them. I also think just thinking about different things we should be thinking about. I think it's worth also looking at the kinds of events that the justices are participating in, and meetings. I think there's, for example, it is now, quite often that justices are making appearances with prominent political leaders, or having, private dinners with those leaders, participating in events that are at least indirectly used for fundraising purposes for organizations. There's a lot, I think there that is also worth looking at. And I think especially in the sort of sui generis moment that we're in, right? This is the first time in, a very long time that you have a court where the justices on that court, their ideological composition corresponds perfectly with the political party of the president that nominated them. Like, we are in a moment where we have a particularly kind of ideologically divided and with a partisan valence court. And I think that creates even more urgency around creating norms and guardrails to discourage kind of behavior that could be perceived by the public as political.
But you have all 9 judges it's not a Republican Democrat issue as to who's for a code and who's not for a code. It seems that all 9 judges recently have indicated they don't want a code. Isn't that right?
All 9 justices signed the letter to Senator Durbin. It's not clear that letter was about whether Justice Roberts had to testify before the Senate. It's not clear that mapped directly onto the positions of the justices about a code. We don't know.
I think the way the court works, all it takes is one opposing it, and you're not likely to get it.
So how do, if you were, and you are all involved in various groups, how do we move the issue forward? There's been legislation issued by some Democrats, I think, urging that the Supreme Court adopt the rules, and if they don't, their budget would be cut or something like that. What would each of you suggest we do to get this moving?
I think a big part of the problem is solvable through the administrative office of the U.S. courts. It is, when we're dealing with recusal issues, part of the problem in a number of these cases has been simply that the data was out of date. The lists of holdings, for example, and those are things that are really management issues that every law firm in the country faces and solves and has to solve. So I think there's a big part of the issue that if everybody's recognizes the problem at the court, a lot of it can be handled through the court's institutions itself. Whether there are outside groups, I don't think, for example, I agree with Stephen Gillers that you don't want to send the Senate Judiciary Committee into the mix, for example. Then you just make the problem worse and more confusing than rather than better. I think the issue of who does the investigation and who does the enforcement is the key issue. And I think it's the big fear at the court. I say this without having interviewed anybody, but I suspect that that is the concern, that they want to control the way their court operates. And I think the best way to do that as a practical matter would be to require each justice who faces an issue like this to raise it in a memorandum, distribute it to the other justices. And I suspect there would be discussion, if not more pieces of paper, if there really is a problem. And I think that that's that we ought to focus on internal institutional mechanisms more than external. I think we're much more likely to get to a solution if we can find one we're comfortable with that does keep the judicial branch in charge of its own issues and problems.
Professor Gillers, since you, I think, were more concerned about getting too far ahead, moving too far ahead quickly, what do you think? You're muted.
The Judicial Conference now has the power, through its interpretation of the Ethics in Government Act, to create vigorous enforcement and disclosure obligations. They've been timid. They grew less timid in March, but there's still too much that can be concealed. The conference, without any further legislation, can change that, can police the failures more effectively than, so far as an outsider can know, now happens. I think the Congress can, and perhaps should, have a sense of the Congress, not necessarily a statute, in favor of the court adopting its own code, could even begin to make suggestions about what that would look like. Remember, the justices must be worried about all the negative publicity. It's nonstop. It's a remarkable flow of harmful publicity and a sinking reputation. So Congress can come to the rescue of the court and say, here are some things you can do. For example, and I looked at the code with a view toward how it could be adopted for the justices, I think we'd go a long way by applying canons 1 and 2 and the first paragraph of canon 4. Those are the general statements that Judge Gertner was referring to. You can get into the weeds on some of the more detailed prohibitions and limitations, and we can. But I think if you begin there, no one could disagree with the broad prohibitions in those portions of the current code. And I think Congress can commend them, and perhaps a few others to the court, in this resolution as an opening bid for the court to then respond and save itself from the ongoing negativity that it is suffering.
Can I just add to that? We talk about the perils of doing something and the issues with respect to that. I really want to talk about the perils of not doing something and the impunity that that has enabled some members of this court to have. So I take, whether it is the congressional state of the body resolution, whether it is the judicial conference, it seems to me something should be done. We also should look abroad. Other high courts whose independence we do not deny have internal disciplinary mechanisms internal to the court, a code of conduct internal to the court. I believe, one other possibility which is implicit in what Russ Wheeler was saying is, and what Alicia was saying is some investigative body associated with the judicial conference that functions like an inspector general and makes a report, confidential, or not something that would see a statement of wrongdoing. In other words, it cannot be that the answer here is nothing, because that then goes to the perils of doing nothing, which I think is a very both. And I'm in concern about the perils of doing nothing. I'm not just concerned about the Supreme Court's reputation, although that's part of it. I'm also concerned about what sense of impunity it conveys to the justices themselves. So I think Professor Giller's suggestions are important. The judicial conference should be emboldened to do more, but something has to be done.
Yeah, anybody else want to comment on that? What about, some of you were, I guess, Nancy, you were on the future of the Supreme Court, the Biden group. Are any of it, did this issue, assuming you want to talk about it, did this issue come up, or any of the solutions that were being thrown out, would they be dealing with this at all, at least in terms of imposing a threat if they didn't adopt an ethics rule, that the court might be expanded or get some other changes?
The report had a section on judicial ethics. It had a report on the legislation that Professor Gillers was just talking about, and it simply described the pros and cons. It did not lay out recommendation. The White House Commission report was actually not intended to give recommendations, but simply to lay out the pros and cons. And so that's what it did. And the kinds of issues we're talking about here are in that report.
So are there any?
Can I turn
Sure.
at some point, maybe not this point, to the issue of recusal and why we should not worry about it? We should not worry about the fact of a recusal. Is that all right, Michael?
Sure, go ahead.
Okay, so one of my qualms, one of my worries in the Roberts defense of no action is recusal of a justice leaves 8 and you can have a divided court. That's not necessarily true. You can have a 5-3 opinion or a 6-2 opinion. And so what if you'd have a divided court? Is it better not to have a divided court and instead to have a justice who should be recused participating in a 4-4 tiebreaker? I mean, that's what he's saying. If we lose this justice, we may be 4-4. Let this justice, who nonetheless is recused under the statute, participate, so we're 5-4. That doesn't make any sense. That's exactly what you want to avoid. If you're 4-4, okay, it's dismissed or affirmed without precedential value, and the issue comes back to you later on. You're not recused because of the issue. You're recused for some other reason. Robert seems to suggest, he seems to conflate the fear of the harm caused by a recusal with the prospect of a code for the court. But recusal will not come from a code for the court. Recusal comes from something that is already there, whether or not there's a code for the court, a statute that mandates recusal under certain circumstances. So the two are apples and oranges, or apples and oak trees. They're totally unrelated. And I unfortunately, his letter to Durbin and his appended item and his speech 11 years ago could be read to suggest that even adopting a code threatens paralysis through the loss of a vote on a particular case where that vote shouldn't even have been allowed in the first instance.
That's a great point.
I never read just the Chief Justice as you know more about it than I do. I never read the Chief Justice as confusing those two things, saying that adoption of a code could lead to these 4-4 splits. I don't recall it that way. But here's another area we could get perhaps created. You know, a couple of years ago, several senators introduced a bill that would allow a retired justice to sit in a case in which there was a 4-4 tie. Whatever gets there, that just came and went. There's such a lack of curiosity about how alternatives might work. And looking to the states, looking to the foreign countries, we just sort of, in that letter, you know, we got the whole about recusals. The justice's letter laid out this scenario in which there'd be all these tactical machinations on the part of the justices to keep, you know, their ideological opponents off a case. Maybe that would happen, but I'd like to know whether in places where those rules are in place, that does happen. I don't think it would not, you know, end the discussion, but at least it would enlighten it beyond just pure speculation now about a parade of horrors anytime we do anything.
Because it's a paralysis, because it leads to paralysis in addressing a really hard problem.
There's recusal, though, if the issues also, do you recuse or not recuse? And do you have to write an opinion explaining why you are not recusing or are recusing? Is that part of this issue?
Well, I think the question is, if a justice recuses sua sponte, do they have to write an explanation of why they did? That's where you get Justice Kagan with this little one-sentence explanation of why she was recusing in the certiorari denial. Then the other question is, if there is a general, as there is with Thomas now, there's no motion for him to recuse himself in any case, as far as I'm aware. But given the press attention, should he have to explain why he's not recusing? I think that's if that's the proposal, I think it's pretty dangerous, because I don't know where you start drawing the line there. But whether justices should have to explain why they deny recusal motions, you know, in most of the states, there's some requirement for it, because you can read Justice Rehnquist's Laird Tatum opinion, in which he laid out the reasons why they shouldn't do it. But again, there's not much discussion of it. That's what's frustrating to me.
Well, what would keep, why a situation where a justice recuses themselves sua sponte could well be personal relationships you don't want to disclose. Yeah. That's one thing, and that is a much more difficult situation. But in a situation where there has been a motion, in other words, it has been litigated, it has been surfaced. It seems to me there's no explanation, there's no justification for a judge not saying, I'm going to turn this down and here's why.
I agree.
And that comes to another issue of impunity here, that somehow, because of concerns about judicial independence, we are not asking the court to be judicial. Tell us why. And be concerned about that. Doesn't make any sense.
And sometimes when you have to write an explanation, you find out that the reason you decided a certain way isn't quite as good a reason as you thought it was.
That's right. It's called the opinion doesn't write.
Right. That's what I'm referring to.
aside from the issue of accepting gifts and recusal, there's some who have suggested there should be rules as to how much a judge can speak out on a particular political issue. And I think Ruth Ginsburg, I remember, was criticized a number of times for that. Is that with these issues covered by the existing code of conduct, or should they be?
They are covered by the existing code of conduct in Canon 4, and I guess 3 to a degree, which encourages them to speak out on matters of the law and judicial administration, but otherwise not. I don't know how you legislate something like that, though, other than perhaps, you don't speak to a group that has a litigation before the court. I mean, you could write some rules, but I think a lot of that has to be is common sense, an abundance of which there is not necessarily present.
Right. There's also been, some First Amendment litigations and limits put on those judicial conduct rules as well. So there's the White case in, I think it was the early 2000s, that limited certain kinds of, there had been restrictions, I think particularly on for state judges on campaign speech, and particular limits on sort of speaking about issues of public concern, and the Supreme Court kind of cabined that.
Okay. Why don't we, any other particular topics before we get to sort of a summation? Any other issues that we should be discussing? Tom?
I'd just like to before we move elsewhere, to come back to this question of whether Justice Thomas was required to disclose the vacations, for want of a better term, that he took. The language of the rules, both in the state court and the federal court, are that social hospitality is not required to be disclosed. Now, that to most people means, and I think was intended to mean, you can go to your neighbor's house for dinner and you don't have to report every time you do, even if they serve a nice wine and the cost of the dinner was substantial. The question, there is a 60-page book that describes to the judges how to fill out these forms. And basically what it says is, if you have a gift, if you have something given to you by a judge, by a non-judge, who is giving you, inviting you to his or her own place of residence, or inviting you to use his own means of conveyance, that does not have to be reported. That wasn't something Justice Thomas made up. We don't know who gave him the advice, but it is not at all obvious that he was wrong in what he failed to do. Now, the Judicial Conference has changed, and my understanding is Justice Thomas has agreed that he will comply with the reporting requirements as they now are, that if the gift was of transportation in lieu of commercial transportation, namely the private plane, then it must be reported. If it is a gift of a trip to a facility that is owned by an entity that is owned by a person, it doesn't qualify as property of the person. I think these are kind of hair-splitting distinctions, but the point is, when you get into a code and the application of a code to the judges, there are going to be differences of opinion. I agree with the people who, I think virtually everybody has said there ought to be ways of getting advice from the judicial conference or others. There ought to be ways of investigating whether the justice made a good faith decision as to what to report. But I'd hate to leave tonight's discussion with an idea that certainly many have tried to convey, I don't mean here, but in the newspapers and elsewhere, that it was self-evident that Justice Thomas was hiding something. I think it is not self-evident. It would have happened. I don't know Justice Thomas, and I can't read his mind. But I think it's important to understand there will always be ambiguity, and that I at least would give him the benefit of the doubt in this case, as long as he complies going forward.
So let me respond to that, if I might, because this also touches on the imprecise drafting of the judicial conference's rules as they were during the Crow generosity and as they are now. So one does not have to report food, lodging, or entertainment, okay, at the home or on property or facilities of the donor. Now, is a yacht a facility? Because Justice Thomas enjoyed a lot of yacht trips. The rules as they were at the time did not allow him to fail to report the private plane. And they do not allow that now. There is no argument he has that there was any ambiguity about the private plane. The plane is not a facility. He could not have done that. But the rules as they are now should be changed so that all munificence from any source other than a relative and relative adjuncts must be reported, so that no one can argue that there's ambiguity, as he argued after he was discovered. He said he will now comply. He said that, I think we can understand, because ProPublica reported on what he had been doing. So now he will comply. What we need now is a tightened rule that allows for no slippage, easy to write, but the judicial conference hasn't written it.
Well, Stephen, I understand what you're saying, and it makes my point that when we go to a code, we're going to get lots of technical, or at least potentially, lots of technical distinctions. And I would encourage us to not start implying moral culpability to somebody who, as I read these, the ambiguous language, could well have understood it as he said he understood it.
Well, I don't know what the word moral means in that situation, Tom, but what he said when the ProPublica report came out, he didn't say, oh, but I looked at the language and the language was ambiguous and I interpreted it this way. And now it turns out I was wrong, but I was not unreasonable. It was a non-frivolous argument. That's not what he said. He said, I asked around a few years into my tenure on the court, and other justices and judges said, oh, what you want to do or what you got, you do not have to report. That's what he said. Named none of them. Some of them would now be dead. Named none of them, and did not say that as the statute got amended over the years and the regulations got amended over the years, he continued to monitor the situation to ensure that the advice he got in the 90s remained correct. So I
agree with,
we don't know what he asked about in 1991, 92. He could have asked in 1992 whether he could stay overnight at a friend's house, and that became a get out of jail card for flying around the world on Harlan Crow's dime.
Right, and he hasn't told us.
I think that we shouldn't get into a debate about Justice Thomas, but I really do think that the enormity of the failure to disclose, the amount of money involved, the regularity of it, One report was talking about how he used Crow's private plane for a speech in New Haven, which is not even arguably non-disclosable. So I think that his case is his case, but to suggest that these were technicalities is just not true. I think the reason for the plummet in the people's confidence in the court comes from the fact that this was really not a technicality. And if we are presuming the good faith of the justices, then the good faith of the justices has to include erring on the side of disclosure when you can, and not parsing those regulations.
What about the rules extending to spouses? Part of what Justice Thomas was doing relates to what his spouse was doing. Do the rules cover spousal conduct, and should they?
Well,
They
there's-
say if you take the spouse along with you, you've got to report it.
But if they make a contribution to some organization that the spouse is very involved in, for example, any prohibition on that?
I think there's a difference between limiting what a spouse can do on the one hand, which is problematic. I was married to the legal director of the American Civil Liberties Union. I could hardly limit what he was doing. But what I could do, which is I think what the Thomas case raises, is if his conduct crossed into my court, that's a different issue. So the Thomas issue, the Ginny Thomas issue, is not so much about her activities as the way in which her activities implicated the cases that were before the Supreme Court. I think those are two separate questions.
Okay. Well, why don't we sort of summarize now where we're going, and why don't each of you say, if given the practicalities of things, what would you propose the court and or Congress do tomorrow to get this problem behind us? Let me start with Alicia.
Well, I agree with what many people have said, that the court could solve many of these problems itself by voluntarily adopting the code of conduct, adopting practices around giving recusal, giving reasons for denying recusal motions, ensuring kind of, as Judge Gertner was just saying, kind of erring on the side of transparency. So I do think that should be a continued drumbeat. I also think, though, that it is well within Congress's power to also legislate. And I think there is a helpful back and forth. I think Congress paying more attention to these issues, having hearings, bills being introduced is a very healthy and important counterpoint to the judiciary. And we've seen many times that can also impact the court's behavior. With respect to what specifically Congress can do, I think, certainly imposing a code of conduct, I think requiring recusal explanations, and I do think it's worth, I think, as I said, these are complex issues, but I think looking at ways that Congress could kind of help create bodies that could then themselves play a role in giving advisory opinions, doing fact finding, et cetera, to create more transparency around what the court is doing are all things worth considering.
Professor Gillers, if you...
Well, yeah. So let me just say how I comment this. I think we as lawyers would agree that the Article III courts created by the framers was a brilliant stroke of genius. They are one of the most successful and impressive institutions of Western civilization. And so assaults on the integrity of the Article III courts, and especially on the Supreme Court, I take personally. I'm offended by it. I need that court to be what it is, even if I disagree with its opinions. And what the Thomases have done has hurt. We know that from the public polls, has hurt the court. But I'm also reluctant to do anything dramatic. I want to go slow. And I think a resolution by the Congress, not even a statute, doesn't have the demand of a statute, but a resolution with suggestions, starting a conversation, how Congress working with the court can help the court's current predicament, and it is a predicament, is the way to begin.
Thank you. Russell, what do you think we should do?
Well, I was hoping I'd go last and I could just say I agree with everybody else. I take Professor Giller's point that we ought to go slow. And I think implicit in a lot of what he's saying is that the Thomas has never come along. We might not be having a lot of these discussions. On the other hand, I also agree entirely with him and others that although Congress is unlikely to do anything, the court is a little more likely to do anything. This can be a time to at least to assess more than we have alternative approaches to the problems that we're facing now. And just to repeat myself, to look to the states, to look elsewhere, and try to figure out how different approaches might work is worth doing now, because I don't think this is going to go away, even if the Thomases were to leave tomorrow.
Mr. Morgan.
I would encourage the court to voluntarily adopt a code. I think there would be no real problem of their adopting the existing code of conduct for United States judges. Most of them have served on a lower court before. They are used to following those directions and guidelines, and I would encourage them to voluntarily do that. I would encourage them to use the existing institutions of the judiciary, including the Administrative Office of the United States Courts and the Judicial Conference of the United States, and from those bodies, develop the institutions that monitor, give advice, give counsel, whatever, on close questions. But I would encourage us to recognize that there are going to be close questions of what is supposed to be disclosed, when recusal is supposed to occur, and that they should, that we should recognize that the failure to agree with us in each case is not a failing that justifies external discipline.
Judge Gertner.
I agree with everyone. This is the Russell Wheeler point. But I think that as I said, the wringing one's hands at the complexity of the problem encourages impunity. Just the wringing of one's hands. And so what's the opposite of wringing your hands? It seems to me that the disclosure requirements, which the court has adopted, need to be made more precise along the lines that Professor Gillers has suggested. I think that recusal standards should be more clear, likewise, along the lines that we've all talked about. I agree that the Supreme Court should adopt its own code of conduct, but in failing that, the Judicial Conference should step up to the plate. And I also think that Congress has a role. I think Alicia put it best: there's judicial independence on the one hand, but checks and balances on the other. And there are a host of ways in which Congress intersects with the court. I know that that's fraught. I know there are issues with respect to that, but I believe that Congress could at least, Professor Giller's resolution is a great idea, to come up with some resolution about the sense of the body, about what the Supreme Court should do. And I think we should look to other countries that have had high courts that are powerful and that have created enforcement mechanisms without destroying judicial independence. But the worst thing we could do is to say, as many have said, there's nothing we can do, because that only makes the situation worse.
Well, it's very good. Before we conclude and open this up to questions, any other comments any of the panelists want to make, and I see for some reason we're not seeing Professor Gillers. But any of you want to add any comments before we move to the question period? There we go.
I'd like to add just one, and it's just a pet peeve of mine, but I'll keep it very brief. There is more misinformation floating around the atmosphere about this whole question than you can imagine. And I think it should be a responsibility of the press, and I'm including major national news outlets, to be a little more concerned about getting basic facts right when they report about these matters. I don't want to dwell on it. I don't want to name the outlets, but there's some awfully sloppy reporting going on, and that doesn't help matters at all.
Okay. Well, why don't we have the Bar Association wants to ask one more question, and then we will open it up. I said we have a number of questions that have been asked. So Bar Association, can you ask the last question, please? And once you have, people just have to think that through and let me know when you have ready to answer, or just put up the results. Okay, I think this should be enough time. Can you give us the results, please? Here we go.
Wow.
Well, I think we persuaded one or two people out there. Thank you very much, everyone, for participating in that. So now, Ed Murray, do you have access to the questions that could be asked?
I sure do. Good evening, everyone. And thank you, Michael and panelists, for joining in this discussion. Very important topic, and I appreciate you sharing your time and expertise. I'm Ed Murray. I chair the Government and Ethics Committee at the City Bar. We sponsored this event tonight, and we had a number of wonderful organizations that were co-sponsoring this. So thank you for your assistance there. I also wanted to give a shout out to Mary Prentice and Melissa Cinturon Hernandez, who were involved in organizing this event tonight. So thank you so much for your help. We have a number of questions. I will just get to it. And any of the panelists who want to jump and answer, please do. The first one here is, what is to be done about Justice Thomas, who refused to recuse on matters related to disclosure of Trump documents when Ginny Thomas was involved in the planning of January 6th? We've touched on recusal, but if anyone has thoughts on this issue or how to address this type of issue, please jump in.
Well, I mean, let me say that if Justice Thomas had been Judge Thomas in the District of Massachusetts, for example, then a party who found out about that could then move to recuse. And Judge Thomas's failure to do so would be appealed to the First Circuit. And the First Circuit would make a decision about whether recusal was appropriate. That's the core of the problem here. One was that to whom does the motion to recuse go once he has denied it? What's the appeal from, and what's the mechanism? That's the core of the problem. Right now, there is no way to address that, frankly, except the media's exposure of it, but there's no way to enforce it.
Does anyone have thoughts on the mechanism or a potential mechanism?
Well, let's be clear here. I don't think anyone has moved. I'm well aware anybody has moved Justice Thomas's recusal or moved them in those cases. So it becomes a question of, as you say, of whether the press and others, and one often hears in response to this complaint, well, Justice Thomas is very conservative. He probably would have decided those cases anyway, even if his wife talked to him about them and she said she didn't. But that's not the real issue. The real issue is the what it does about the impression of the court. It just doesn't look good, and it's a bad thing when the court does stuff that doesn't look good and is easily remedied. And that's the situation we have.
This was, when you think about reasonably likely to, cast doubt on the partiality of of
Right.
the impartiality of the court. This is a situation which he should have erred on the side of recusal. But you're right, not clear that people knew about it until after the fact and until the press came out with it. What apropos of, I think it was your proposal, Russ, or somebody's proposal, the Judicial Conference could come out with paradigmatic examples of recusal and circulate that. And this could be in it for going forward.
Professor Gillers, do you have thoughts on a recusal mechanism?
Well, as regards justice, I think we just have to live with Justice Thomas. I don't think anything can be done. He does not seem to be, so far as we can tell, affected by the criticism. I worry that his mother is in her 90s. I mean, he could wind up being the longest sitting Supreme Court justice in history. But I think the solution, whatever it might be worse than their problem. He's there. We have to accept that. Maybe the criticism will help. More likely, the criticism will cause his colleagues quietly to talk to him. That would be nice, but I don't think there's anything more we can do.
This question is from Patrick Sline. Short of impeachment, what would proceedings against a Supreme Court justice under an ethical code accomplish? Wouldn't such proceedings have the potential of raising skepticism over the validity and finality of Supreme Court decisions? Professor Morgan, do you have thoughts on that?
I don't know what it would do to a perception of finality. That is, I think Professor Gillers is right that if he does not recuse and we do not have a mechanism for the court or some other body to review that failure to recuse, he votes and the decision is the decision. I agree with the implication in the question that a failure to provide a mechanism that provides a sense that people not biased or not appropriate for recusal had agreed with him. The failure to have that system makes it inevitable that there's going to be some people who don't trust the decision or don't trust his vote, at least.
The question is whether this is profoundly any different from what, and maybe it is, from the fact that when a justice's papers are become public or an author writes about them, it's not unusual, maybe inappropriate, not unusual for there to be a discussion about why he voted for X or Y, or just sort of a post hoc investigation. And it doesn't cast doubt on the finality of the decisions that were made. It more significantly suggests that the court is a human institution and the norms have changed.
I think it may be worth mentioning that the court itself, in a couple of decisions, has made the point that the fact that you had a large majority for a result, if somebody should have recused themselves, you don't know how persuasive they were in the room that they shouldn't have been in discussing the result. So I don't think it's sufficient to say that you can simply, it's only 5-4 decisions where a failure to recuse matters. And I agree with those who are arguing that if recusal is appropriate, there ought to be a mechanism for bringing that home to the justice and achieving that result. If the justice doesn't see the fact himself or herself.
But
the one thing I'll just add is I don't think it's been good for the public legitimacy of the court for for everything to be sort of shrouded in secrecy and to have things trickling out over time. I mean, I think having mechanisms for transparency, reason giving, and public scrutiny if justices fail to recuse when it's plain that they should is healthier than a dynamic where there aren't opportunities to identify that, and it only comes out through a media report years later.
But the question is not about recusal. The question was, short of impeachment, what would proceedings against the justice under an ethical code accomplish? And here I think it is important to recognize that the sanctions imposed on lower court federal judges for violation of the code that does bind them are almost, first of all, are very few and are almost always not public. So it's not like we'll have a broad public revelation if we have a mechanism akin to the one for policing lower court judges. What we will have is, on rare occasion, without us knowing it, that a justice was privately reprimanded, if it even got to that point. So when we talk about what will it accomplish, that ought to play into our view about whether an enforcement mechanism outside the court is wise.
Okay, go ahead.
Our next question is from Ron Goldbrenner, who asks, to what extent does a justice's oath impose a legal duty to act ethically, in good faith, unbiased, to do the right thing?
I mean, the answer is yes. In fact, some people have looked to the fact that Congress prescribes the oath of office as an indication of Congress's authority to at least impose some aspirational goals. But yes, that oath does impose a legal duty to act ethically in good faith and unbiased. The problem, as we've all been talking about, is not is what that consists of in specific cases and how to enforce it, and that's the issue.
And of course, the oath makes the code of conduct look specific.
Right. Right.
Here's a question from Karen Orland. There were a couple of comments regarding ethics rules and recusal rules in courts around high courts around the country, around the world. I wonder if anybody has any specifics on that issue.
I don't have specifics. I mean, there are, and I don't have specifics, but there are subcommittees of senior court judges throughout the system that can look at the behavior of high court judges. There are investigative mechanisms like an inspector general to look at the behavior of Supreme Court justices. I don't have the particular countries, but I think it's fair to say, and maybe Professor Gillis would know more specifically, that we are the only country with no enforcement, no ethics rules for justices, and no enforcement mechanism whatsoever short of impeachment. And what we know is that other countries have created mechanisms short of that, some of the ones that I've described.
I was just going to say, the fact that you don't know them is not dispositive. The question is whether or not anybody's even bothered to look, and that's my point. That there are examples out there that can be analyzed, and just to see if they're applicable. And there's been relatively little interest in doing that.
Good.
That seems to be a call of action for the city bar here, Mr. Wheeler. And one final question here. If bribery committed by the Supreme Court justice is actionable, why can't all other bad conduct designated by Congress be actionable, including taking big gifts?
Because bribery is a crime. So I think we all agree that crossing the line into crime would be a different matter.
Well, and the disclosure statute does have civil and criminal penalties, right, for willful failures.
Right, which is my understanding that Justice Thomas is to ask for more time to amend his disclosure forms. And I imagine he's doing it with that in mind.
Okay, is that it, Ed?
That's it.
Well, let me just say then, first of all, I want to thank the City Bar and the co-sponsoring organizations for organizing this very interesting program. And particularly, I want to thank the Government Ethics Committee and Ed Murray, its chair, for putting this all together. And most importantly, I want to give an enormous shout out and thank you to the panelists for taking the time and presenting what I thought was a very special, interesting, and clearly very, very important program. So thank you all. It was a pleasure to moderate you.
Thank you.
Thank you.
Yeah.